Jonathan Pollard, non-compete and trade secrets attorney in downtown Fort Lauderdale, Florida. And I'm going to talk today about specialty medical practices and physician non-compete agreements. In many states, physician non-compete agreements are either unenforceable or subject to very rigorous scrutiny. So you have some states like California where employee non-compete agreements, including physician non-compete agreements, are unenforceable entirely, void as a matter of public policy. You have other states like Delaware, like Massachusetts, where physician non-compete agreements are unenforceable. Then you have other states like North Carolina where physician non-compete agreements may be enforceable but are subject to very rigorous scrutiny. Finally, you have a handful of states like Florida, which are about as far along the pro-enforcement spectrum as you can get. Florida is, in my view and based on my experience, the most aggressively pro-non-compete state in the entire country. This includes physician non-compete agreements. Although the law is a mixed bag and there are a number of open questions in the realm of physician non-compete agreements, it is clear that Florida courts will enforce these agreements in many circumstances and enforce them to some significant extent. The specific issue I'd like to talk about today is specialty medical practices and how this bears upon the enforceability of a Florida physician non-compete agreement. You have a family practitioner, a family doctor, family medical practice. The patients are likely to be long-term patients of the practice. The doctor becomes the family doctor, treats the parents, treats the children. That's a long-term doctor-patient relationship. And ultimately, physician non-compete cases tend to be about patient relationships. A physician leaves one medical practice, starts a competing practice, and patients want to follow. And so the non-compete agreement and non-compete litigation is used to prevent that doctor from leaving and taking those patients with him. That is the sort of paradigmatic physician non-compete case. But when you get into specialty medicine, more specialized practices, that is not the standard fact pattern. You have to step back and you have to understand that a non-compete agreement is only enforceable, even in Florida, a non-compete agreement is only enforceable if it is necessary to protect a legitimate business interest. The legitimate business interest in the context of medicine, of doctors, is either going to be some type of confidential information, patient relationships, or extraordinary or specialized training or investment in the employee. And in most contexts, you don't have any confidential information because the physician is purely a treating physician. It's not involved in kind of back office. You do have patient relationships, and that's usually the big ticket item. And you don't have really the education, training, or investment issue that often. So most of these cases are about patient relationships. But when you get into the context of a medical specialist, that is not an issue on the table. You look at the nature of the practice and you understand this to be true. So take, for example, neonatologist. You have a neonatologist who does work with newborns. There's no patient relationship there. The child is born and then the physician treats the child, and God willing, the child gets better, is healthy, is released from the hospital, and that's the end of the doctor-patient relationship. There really is no doctor-patient relationship. So in the context of neonatology or in the context of heart surgery or any number of other specialties, it is not a situation where there are doctor-patient relationships that can plausibly be protected. So when you're dealing with a medical specialty, this is an area that is absolutely fertile ground for challenging the enforceability of a physician non-compete agreement based on a lack of legitimate business interest. It's not simply territory where you can sit back and play defense and fight a case on these grounds if someone sues. This is also territory that is ripe for declaratory judgment litigation. This is the sort of clear-cut fact pattern that can serve as the predicate for declaratory judgment. So if you are a medical specialist and you have a non-compete situation, you're leaving one practice, you're joining another, you're purchasing another, you're launching your own, and you're already experiencing some static with respect to your non-compete agreement. Your old practice is threatening to enforce a non-compete agreement against you, and you're a medical specialist, or if they've already sued you and you're actively involved in litigation, you have a number of defenses at your disposal, and perhaps most significant and paramount among them is the fact that given the nature of your practice, given the kind of structure of the industry at that level in terms of who the patients are, how the patients are sourced, there may be no legitimate business interest because most of these physician non-compete cases are about patient relationships. And when we're dealing with medical specialists, the patients are not long-term patients. Those relationships are not entitled to protection. Therefore, there's no legitimate business interest, and the non-compete agreement should be unenforceable. So if you're a doctor, if you have any questions, concerns about a non-compete agreement, about a non-compete issue, please feel free to give me a call. Jonathan Pollard, non-compete and trade secrets attorney in downtown Fort Lauderdale, Florida. Thank you for watching and have a good day.